Alright, here is your Unit 6 review, starting with your civil liberties. It's your basic freedoms guaranteed by the Bill of Rights, found in the Bill of Rights. It protects you from intrusion, or protects you against the government. Your 14th Amendment, first off, it made slave citizens, does have the Due Process Clause, which we would get to, and the Equal Protection Clause as well. Idea of selective incorporation, you need to know how to define this term. Selective, picking and choosing, incorporating to include the 14th Amendment. It was a sudden change. Some of the liberties listed in the Bill of Rights have been applied to the states using the 14th Amendment. It was a slow process, however. In 1833, Barron v. Baltimore, the first case we brought up, the individual said the city of Baltimore was violating his Fifth Amendment, but the Supreme Court said the Bill of Rights and the Fifth Amendment does not apply to the states. In Gitlow v. New York, in the 1925 Red Scare case, espionage, talking about providing information about or against the government, it did convict this individual. It was his freedom of speech was not protected. However, it did say the Bill of Rights and the First Amendment does apply to the states. 15th Amendment, civil rights. Your civil rights are your basic right to be free from unequal treatment based on those three things. The primary difference then between your rights and your liberties, your rights are actions government should take to help create equality amongst everyone, versus your liberties are protecting against any government type action. Plessy v. Ferguson, separate but equal clause or statement meaning that racial segregation was okay. Brown v. Board reverses this decision. Separate but equal is not okay. It begins in schools. De jure segregation violates the Constitution and the 14th Amendment. So the idea of Brown v. Board was to desegregate, but also to integrate students into the school system. Civil Rights Act outlaws discrimination based on race, color, religion, and sex. University of California case was the admission to grad school. They can use race as one of the factors in admission, but cannot be the only, and they cannot have a quota system. In your Boy Scouts case, private organizations do not need to follow. They can kick people out. They can include who they would like. In your Lawrence v. Texas, again, they allow, this says same-sex activity is okay, and you cannot pass legislation and convict people of performing or having those relationships. Reed v. Reed, the mom and dad, divorce, the state of their deceased son is passed down, and it said that the male had precedence over it. However, they say you cannot favor based on sex who these objects go to. In your freedom of speech cases, the positions that the Supreme Court takes, you can use offensive words, you can do things symbolically like armbands in Tinker v. Des Moines or burn flags, and you can also protect you in contributing money to campaign finance. One of the tests they use in clear and present danger tests is in order to determine what circumstances limits the First Amendment. Is there imminent danger? Are these actions going to harm someone? And then the obscenity, that's kind of left up to the states. Do the average people feel that it was obscene? Does it lack things like literary, artistic, political, or scientific value? And then the necessary to prove libel and slander, you must show that the statements are false, the things that are said or written about you are false, and that they were done with malice. Your rights at school, Tinker v. Des Moines, you're allowed to peacefully protest as long as it doesn't affect the environment of the school atmosphere, and that means that you are protected by your First Amendment. In your Fourth Amendment case, the TLO v. New Jersey, your rights are limited in searches and seizures. All the school needs is a reasonable suspicion, which is less than probable cause. Due process, privacy, again, we have Warren Court, Earl Warren, overheard. He was Chief Justice in many cases that helped change society. He was a judicial activist. In your due process, this means that the states must respect all legal rights that are owed to a person. Your Miranda v. Arizona is your Miranda rights. Your rights must be read when you are being arrested. Your probable cause, reasonable grounds, it must have more than reasonable suspicion to search or to press charges against someone, to arrest someone. In your Mapp v. Ohio case, they had an illegal search. This set up the exclusionary rule in evidence, meaning that if there is an illegal search, all the evidence that is obtained in that search must be thrown out as evidence in the case. And this usually throws out the case because there's no evidence. Parker v. Gladden, a bailiff was saying that this individual was guilty to some of the jurors, and this, they said, violates the Sixth Amendment. You must have a right to a fair trial. Gideon versus Wainwright, individual could not afford and was not given or provided a lawyer. They said you must provide lawyers in all cases to those that cannot afford one. In primary restraint, this doesn't really happen in the United States government because the First Amendment severely limits it. This is censoring any publications from news outlets that would be deemed harmful. Then your right to privacy in the United States. Personal information is protected from public scrutiny. You have the right to be left alone. And the last three here are dealing with your First Amendment rights and religion. Again, laws cannot prevent free exercise of religion. You are free to practice any religion you would like. There's a ban on all laws that are respecting an establishment of religion, so an establishment of religion by the state or by the government. And then the last one in this case, Yoder versus Wisconsin, the Amish case, where the individual wanted to stop going to school after 8th grade. They said sometimes religion does outweigh states' educational interests.